She's at the public defender's office?
No, I was gonna say she's not with the public defender's office.
Yeah, I didn't think so.
Not unless.
Oh, okay. I didn't know her first name, and that was the only name that the phone number when I pulled it up in CPU8.
Yeah,
Yeah,
what I have is Natalie Gasson. Because I was looking it up. I think she's the one that signed a bond waiver at prelims. It looks like is where I got that name from.
Natalie Gaston.
Right. Yes. I think it's Gatson, if I remember correct.
Yeah, I searched for her in our emails as well. Okay.
Yeah, if you can see the waiver, that's where I got that information. And I know she's not with our office. That's why.
Okay, because I think it was Andrea. Y'all have an Andrea Gaston, right? Or
don't get me to. I don't know.
That was the name that came up when I typed in Gaston. It was somebody from the from the public defender's office. But I'm on it.
Okay.
All right. Thank
you. We
have
not reached her by the end of the hearing for Powell. I'm just going to dismiss it.
Let me double check because I think Ms. Davis sent me something earlier. She'd actually offered. I think she sent me something with a list of who she has. So let me double check to make sure I'm not wrong about something. Yeah, she doesn't have Mr. Price on our list either. She kind of ran down for me, which of our attorneys have which cases on here, and he's not listed on her list either. So I'm thinking that's probably what it's about.
And I'm also checking on the motion to set bond. But see, on the motion to set bond is Justin Jones. So that's why I was calling the public defender's office. You muted, Attorney Rogers.
I was going to say we probably need to continue that one because there seems to be some confusion. Because if Ms. Gaston had it, that would imply to me that there was a conflict somewhere. I don't know why Mr.
Yeah, we received the motion from Justin Jones.
Yeah, I would ask for a continuance on that one, Judge, because I don't know why he would have filed a motion on something.
So we'll continue. So you just want me to continue it? Okay.
Yes, ma'am. Because like I said, look, I'll see what I can find out. But seeing as I'm pretty much doing all the hearings left this morning, I don't know how much I'm gonna find out this morning. So
are we continuing it to the 25th as well?
We're gonna continue this to next Friday.
Yeah,
next Friday.
Mm-hmm.
Okay.
And just put no attorney appeared.
Okay.
All right. And so let's do Powell. And so who we were just talking about
Price.
Was Price. I wrote it under Powell. Okay. What's next week's date? Next Friday is the next Friday is the 18th. All right. Now calling the matter of State of Georgia versus Jonathan Powell, charged in warrant numbers 2023 CW 51912, 2023 512913, which is aggravated battery. The 51912 is aggravated assault. 2023 CW 51914 is giving inmate guns or weapons. 2023 CW 115, a riot in the penal institution. Representing the defendant's attorney Rogers, representing the state 88 Thomas. Go ahead, Attorney Rogers, your motion.
Thank you, Judge. First thing I guess I'll say is that, this is a case of 90 days without an indictment on the charges. So at this point, Mr. Powell would be statutorily entitled to a bond. So that's what's going on. I could spend time on the bond factors, but since that's usually going into whether or not to set a bond, I don't know how relevant they are specifically. But I will address, let's be very clear, Mr. Powell has several other cases going on. Like, there's no need to hide the ball on this. He's got more significant cases that he's dealing with. Specifically, I would say arguably the most serious case that a person can have. So whatever bond the court says today is not going to be, dispositive of whether Mr. Powell gets out or does not get out or anything like that. He's dealing with a murder charge and some other charges. However, with all that being said, the first thing I'd say is, regardless of what Mr. Powell's done, the court, the government, all have their parts and their roles to play in this situation. And so to my mind, that's more what this is about. I'm sure the state will try to paint Mr. Powell as some sort of monster or something like that. But for one, just to speak for Mr. Powell, that's not the case. The charges that we're dealing with right now, they're jail-related charges. And what I would say, and I'm sure the court's aware of, because they see the charges that come through too, the jail is not a safe place. Some people, are protecting themselves and some people aren't. The politics of protecting oneself in the jail, it's not, a free world situation. Incarceration has effects on people. So I say all that to say that I don't know that we need to be considering jail charges as reflective of anything really other than the kind of dog-eat-dog world in the jail. To turn to Mr. Powell specifically, he's 32, been in Georgia all his life, got a mom, dad, 3 sisters, a brother, a son, all in Georgia. There's no flight risk in that sense. As I understand it, and I'm sure the state will correct me if I'm wrong, while he does have felonies pending, I'm not sure that he has any felony convictions on his record. And I say that to say that, again, it's a matter of whether or not, the court's going to indulge in putting the cart before the horse. The state may ask for some sort of astronomical bond, but I will point out that, these aren't new charges. If I'm not mistaken, I'll double check before I say it. The warrants start with 2023. As the court knows, that means the charges are, applied for in 2023. Here we are in 2024, almost done with it. And these cases remain unindicted, unaccused. That's why they're still in front of magistrate court. So, the state can't have it both ways where they come in and stress the importance of, some sort of bond that deprives Mr. Powell of any hopes of getting out of jail when they've had ample opportunity to get the case indicted, accused, whatever they want to do about the situation. And that hasn't happened so far. To the extent that Mr. Powell's going to stand on his presumption of innocence, as the court was said, bonds, consistent with standard aggravated assault bonds, aggravated battery, these charges, I would ask that the court set bonds consistent with someone being charged with that but innocent of it and not having felony convictions on their record. So ultimately, all I'm ever asking is that the court essentially not assume facts not in the evidence. Don't assume his guilt based on the fact of charges. Because otherwise, we might as well do away with the courthouse and all these books and laws and rules that we got. If we're just going to do away with that when it's convenient, or if you say enough bad things about somebody or make enough accusations that we just throw it out. The rule book, that is. So for all those reasons, Judge, I would ask that the court would set a bond. Well, let me kind of add a little bit to that. What I was going to say is that I would ask that the court set a bond consistent with aggravated assaults and these types of charges for somebody who's been under these charges for, I'm going to be generous and say at least 10 months. If I give you the end of December until today, we're talking about 10 months. And realistically, it's longer than that. So I would ask that the court would consider setting a bond that is reflective of the record of convictions, not allegations, and also the fact that he's been in this long and is entitled to a bond, and a reasonable bond at this point. He's not a man of means, doesn't own property, doesn't have any savings. He was working, but it was at McDonald's prior to incarceration. So, generally, unless you franchise them, that's not a lucrative career. So I'd ask that the court would set a bond, in the neighborhood of a total of $30,000, $40,000, in light of the fact of the charges of aggravated assault, the fact that he's been in 10 months, and that right now we have against him allegations. So for those reasons, like I said, I ask for a total bond of $30,000. Thank you.
All right. Go ahead. Any comments? We can't hear you.
Yeah, you're on mute, Eddie.
I'm sorry, Aaron. I'm not going to even get into his criminal history because it appears he's created a whole nother criminal history at the jail. He initially came in charged with murder, which is about as bad as it can get. Since he's been there, he has 9 open or pending cases. He, along with about 3 or 4 others, continually assault, beat, and harass other inmates at the jail. This particular case before the court today happened on April the 20th of 2023. A couple more just like this one, just different victims, have happened since this one, where he and at least 2 others stabbed and beat 2 other inmates. Your Honor, if anybody should not get a bond, it would be this gentleman. I understand Mr. Rogers' concerns about it being a 90-day case and all of that. But beyond it being a 90-day case, the court also looks at the defendant's risk to reoffend. If anybody's going to reoffend, it's going to be Jonathan Powell, because he has reoffended since he's been in jail. State would ask the court let this case remain a no bond situation.
All right, final words, Attorney Rogers.
Thank you, Judge. First, I would ask you to disregard the state's request for you to disobey the law. Number one, I think that's a reasonable request to actively ask the judge.
Your Honor, I'm going to take exception to the defense counsel's characterization of my argument as disobeying the law, where a defendant may be eligible or entitled after 90 days. It does not require the court to set a bond if, in the court's discretion, a bond would not be appropriate or warranted. In this case, it would not be.
I would ask,
right.
If the state's going to make that argument, they need to pull out a statute. That's not
the court is not required to set a bond. They're required to consider a bond. They don't have to set a bond if the court does not feel it's required.
Give me one second.
All right.
I'm not sure if this needs to be a debate if the court knows.
I know the law, so I know the law.
So, like I said, the other thing I would point out is that, again, from what I heard, I did not hear the state say Mr. Powell was convicted on this date, that date, of this crime, of that crime. What the court is asking you to do, again, is to just assume that he is guilty and start from that position, which that's not how our courts operate. That's not the Constitution. That's not America. There's other countries where you can behave like that and that's consistent with the law. This ain't that country. There's Russia, North Korea. You got all kinds of countries where you can just hold people with, forever without giving them a bond and all these things. This ain't that country. So I would ask that the court, comply with the law and set a bond, like I said, in the neighborhood of $30,000 for Mr. Powell. Thank you.
Okay. All right. And so for the aggravated assault, I'm going to set a bond for $20,000. For the aggravated battery, $20,000. For the giving inmate guns, $5,000. And a riot in a penal institution, $5,000. thousand, and I believe that's 60,000. I mean, 20, 40, that's 50,000. So 20,000, 20,000, 5 and 5. So yes, 50,000.
Thank you, Judge.
Mhm. All right, and let's see, we have anybody remaining?
Mr. Seymour, Your Honor.
All right.